Welcome to Gray Matter is the color of my hat. I will take it off and show my balding spot over here. We are dealing in Gray Matters with older people and their concerns, and caregivers and family members. Gather around now because this may affect you as well. We're privileged today in having elder law attorney Monica Pacheco. Welcome aboard, Monica.
Thank you, Lee. Nice to see you.
And Monica hails from a place down south, southwest actually, where people practice with the cactus. And it's a little place called Arizona.
That's right. Tucson, Arizona is my hometown.
And she came north from Tucson because
I was ready for a change of scenery, tired of the dirt and the cactus, and wanted to see some of the green. Found myself in Oregon and enjoyed it, so I applied to Willamette University, went to law school, and I've been here since 2003.
Now I'm wondering, most people don't go into law school specifically concentrating on a major focal point. You started not with elder law. What did you begin in law school?
You know, law school is there's no focus or concentration in law school. You take general courses throughout. You can concentrate somewhat in your electives, but really you're supposed to be taking a broad range of courses so that you can find areas in which you have either an interest or an aptitude to help.
And you had told me, you whispered in my ear earlier, Lee Coyne, I always came from a family that wanted to serve people and do things. Can you elaborate on that theme?
Yeah, my family has always served their community. One of my very first memories is in an orphanage where my parents and family worked to take toys and clothes and work on the building for the nuns. And so my job was to play with the kids and entertain them or entertain myself while they worked. So I learned very early on to serve the community in which we live.
And why the transition to the elder folks?
Because I can help. There's so many people in need that without the information and the knowledge and the ability to help people navigate through the process of aging in the law, people get lost. And as we age, we slow down a little bit, we get tired, and so it's a very nice area to be working in, being able to help those in the community.
Good. I like the word navigate. It really grabs me. And I think we're going to navigate the waters of getting older and what it means in terms of estate planning. But first, let's get a broader view. What is elder law and why is it useful to people who are not yet elderly, but people in their families as well, so that you can get a preview of what's coming?
So elder law is generally seen as the area of law that we work in as you age. The magical age to be elderly is 65, but really it's needing assistance either with managing your own life or with care needs. We see a lot of people in need of care, but it also encompasses younger adults or children who are disabled. So elder law really encompasses more than that. I see a lot of families trying to protect their children and their assets of their children who are disabled and receiving either services or benefits. And then the vast majority of our clients are the elderly who are encountering some issue at home or with their care needs where they can no longer provide for their own care. So we're looking at people who are receiving in-home care or care in a community setting. And anytime you need assistance, there's a dollar sign attached to that, and it's very expensive care. So our job is to help navigate through that and figure out what benefits may be available to our citizens, to our veterans, to help pay for that care, to protect assets for their loved ones, make sure that spouses have the houses that they need. So that's essentially what we do. It's important for those who are not elderly because one of the greatest tools we have is the estate plan. The estate plan usually consists of a power of attorney, an advance directive, maybe a will or a trust, but those tools help us in accomplishing the goals that the family has.
You mentioned three things. We'll go through each of them, but with a main focus on the estate plan. Power of attorney does not actually, you need an attorney to put it together?
Well, you're asking an attorney, so my answer is always yes.
Okay.
But the truth is, you don't need an attorney to create a power of attorney. There are forms that you can get.
No, the advance directive is different.
Right. So you can buy forms, you can get a power of attorney from other attorneys. I caution people in that you get what you pay for, meaning that if you're not aware of the future issues that may arise, you're probably not aware of the specific powers that you need to list in the power of attorney.
Okay. Now,
So-
a power of attorney hands over some of your everyday civil rights or liberties, the things that you
Not at all.
Some, I said.
No, not at all.
Oh, what does the power of attorney convey then?
So the power of attorney authorizes the person that you name to help manage your finances, either if you ask them to or if you're not able to. So you don't give away your civil liberties, you just add somebody to assist you.
Okay. Delegating.
We take civil liberties, unfortunately, if you don't have a power of attorney and you're not able to manage your own finances, then we have to go to court and do a conservatorship. And that court action does result in taking that right from you and giving it to somebody else who is then going to help manage your finances for your benefit.
Okay. But a regular power of attorney, you're in control and you say, you trigger it's being activated.
Correct.
That is.
That's absolutely correct.
Yeah. So you're saying, hey, I can't write anymore. My memory is a little bit foggy. I don't want to continue the responsibility of paying my bills
That's
for
correct.
utilities or independent living or what have you. I'd like my friend Joe Blow to do it for me. I'm putting together a document, bring it to the lawyer. The lawyer will make it legally correct and conform to the state statutes and that kind of stuff.
That's pretty accurate. The only piece you're missing is once you have the power of attorney, if you then lose the ability to make that decision, because remember you were making the decision to name
Right.
somebody, once you lose the ability, the document's already in place, so your agent can act on your behalf without your direction.
And it takes a doctor or two doctors, I think, in this state to validate that you're no longer competent to do it.
It depends on what the document says. There's two different types of powers of attorney. One of them's known as a general durable power of attorney, and it is actually valid the moment that you sign it. So you don't need anybody to say
I have
that
one
you're
of
not
those.
capable. Recently, within the last probably 7 years, the Oregon legislature did enact what we call the springing power of attorney. And so that power of attorney does not jump into fruition unless you're incapacitated. And at that point, you need two medical professionals to indicate that you no longer can manage your own finances.
Springing power of attorney. So remember, two different types. One, that you're in control all the time, and the other, that when you be declared incompetent by two doctors, it would be,
Or the court.
or the court, but the court would ask a doctor, right, or not?
Not necessarily. That's a different process that we use. We can use testimony or records from physicians, but generally the doctors don't come to testify. But we can take collateral evidence from what's called a court visitor. It's oftentimes a social worker, from family members. So if we have a hearing, we're putting evidence forth showing that the individual no longer has that capacity.
Interesting. I have a relative, an ex-spouse, who has a power of attorney, but considering revising it, and because the relatives are out of state, they're not in play, and they don't want to fool around, so they have a local person they know from their church and all. But now, beyond the power of attorney, advance directives, and I think, and I'm going to make a point about this for possible future legislation, which we can't pass here today, but an advance directive, and the case over the lady in Florida who had the
Terry
kids-
Schiavo.
the Tribal case, and even before that, there was someone who is in a coma, can't speak, and there was no written evidence to know the person's wishes.
Correct.
The idea of the power of attorney, of the advance directive, deals with medical care and do's and don'ts. Do you get a gastric tube? Do you get fed intravenous? If your body is deteriorating and the doctors see no way to save you, but they're going really a slow march to death, to be very blunt about it. Who makes the decisions if you cannot? You want to elaborate a little bit about that concept?
Sure. So the advance directive today is what many people used to know as a living will. So we used to have a living will. We don't have that anymore. The Oregon legislature codified the advance directive. It's actually a legislative document that the legislature created. Its purpose is threefold. The first part is to allow you to nominate or tell us who you wish to make your decisions if you're no longer able to communicate your own decisions. So you appoint your representative to make those decisions. The second part is whether or not you authorize your representative to make decisions about life support and tube feeding, not at end of life, but for treatment purposes. At the same time, you can limit their authority by writing in different things that you may or may not agree to for your own personal treatment. I had a client once who was very adamant about writing into her advance directive that under no circumstances was her representative to agree to any procedure that would result in a colostomy bag. So you really have the opportunity to tailor what your wishes are for your own care. The final piece relates to the Terry Schiavo case, is telling the doctors, your representatives in the world, what your wishes are with regard to life support and tube feeding. Should you be in one of the 4 conditions that they contemplate, which we see as end-of-life conditions? If you're close to death, if you're permanently unconscious, if you're at the end of a terminal disease and your function is very low, or if life support and tube feeding are not going to help you medically, do you want to receive it anyway? And so the theory is once you complete it, the doctors and your representative agree that that is how you will be treated should you be in one of those conditions and not be able to communicate.
Okay. Can you write in something that concerns the level of pain? Because I know there's no objective way. People say from 1 to 10 we're in the scale, but
Right.
Can you say if I get any pain level above what I perceive as to be 8 or such and such, I will or will not get this kind of treatment?
The premise of the advance directive clearly states that regardless of the life support and tube feeding, you'll always receive your cleanliness and comfort care. And comfort care includes the painkillers. I would imagine that you could write in your wishes, but it is subjective. I would argue that it's subjective, and what's an 8 today may not be an 8 tomorrow. And you're probably going to be restrained by whatever the hospital protocols are anyway for pain relief.
Can you insist in that directive that the doctor consult your representative and not do his or her own thing?
Yes, that very clearly is one of the
Okay. So
possibilities.
the doctor cannot be an absolute authority figure?
If you choose to either receive life support or tube feeding or not to receive life support or tube feeding, the doctor cannot contraindicate you. If you choose to give the physician...
Means to reverse.
Right.
Fancy word.
Right.
Okay, I know. We got to watch out. Not everybody in the audience is as smart as we allege to be. I don't teasing you in that and all. I want to put in a legislative idea I've had in the back of my mind several years, and I know we're not going to accomplish it here in the air if the candidates running for office, governor, secretary of state, the attorney general doesn't come up this year. But I would like to see maybe, as Oregon did the first law in so-called assisted suicide, or they call it death with dignity is a better way to put it. I'd like to see that whenever somebody gets a driver's license, that it become optional, if not mandatory, to have an advance directive, because so many people do have accidents in cars and some of them wind up dying. And I think that should be part of the responsibility, that if you choose to drive a car and you run the risk of having a fatal accident, that advance directive would give your wishes. Or if you're injured and Well, the advance directive will then determine your treatment as a recovering patient, hopefully. Food for thought.
Along those lines, not the legislative lines,
Yeah.
but there is a registry. So if you complete an advance directive, you can register it nationally. We recommend you give it to your doctor and to your hospital, the local hospital, and then they communicate between one another. So in theory, at least within the state of Oregon, if you were in an accident, it should pop up if you've registered it. Also in theory, if it's national and you register it, you should be able to pull it up in California.
Okay, because you cross the border, whatever. Yeah, but I think right now there's no requirement that somebody who gets a driver's license also has to have an advance directive, and I'm suggesting it might be the wave of the future.
That would be interesting.
I'd also like to see that people who get driver's license are given the option of getting first aid, because if they and protected by Good Samaritan laws, because if they see somebody injured and they're trained in first aid and that kind of thing, few lives and limbs could be saved.
That would be possible.
Still an idealist from my
We'll see what happens.
Okay. So stay tuned, all your legislators. You heard it first. You got my permission to use it in your good old campaign, and may it help you reap a few thousand votes extra. Ha. Okay. Let's go to the estate part now.
So
What is estate planning? What does it consist of?
So the estate plan consists of the power of attorney and the advance directive that we just talked about, as well as either a will or a trust. A will is the legal document that we present to the court. So if we're presenting something to the court, in most cases that means we're doing a probate. So if we have a will, we have a probate. And probate is the legal process of transferring title from you, who are now deceased, to your beneficiaries or your heirs. And so the will says, after I die, I want my things to go to my family, my spouse, my children, my friends, to charity. And so that's the will's role in the estate plan. A living trust is different in that it does not require court filings, and so it's not requiring a probate. It requires an administration of the trust. And the goal is the same. From the trust, we create a trust and we put all of your assets into the trust, so your trust owns everything. And then after your death, the trust distributes everything to your beneficiaries after paying your debts and your taxes. However, the trust is called a living trust, so that means that it's also in effect during your lifetime. So a lot of people like to have a trust for various reasons. One of them is privacy. We're not going to put everything into the public sector, into the court where it's public record. But most importantly, there's mechanisms that we build into the trust that allow your successor trustees, the people who are going to help you manage your assets, step in if you become disabled or are no longer able to manage your own finances. So similar to a power of attorney, but everything's in one contained trust, and the mechanism is not very difficult to step in and help your loved one manage their assets and pay their bills. And everything's located centrally in the trust. And then, of course, after your death, you don't have to do a probate. You do a trust administration. So lots of nice things in there.
Let me ask about the probate, because I've heard that term spoken of. But first of all, let's do the bottom line cost. Does a probate is a certain percentage of your estate, or is there an established fee that you pay the courts? How is the expense of a probate measured?
So if we're having a probate, the cost of the court is based on the value of your estate, and it maxes out right at about $800 to get it filed. So it is almost a sliding scale. The more net worth you have, the higher, actually it's gross worth, the higher the filing fee.
And that includes your real estate is considered that not which is not fluid money. It's
correct.
You know.
Correct. It's considered part of the gross estate. And so the value of your estate generates part of the cost. There's a required publication that generates part of the cost. Your personal representative, who's the person managing your estate, is entitled to a fee. That is set as a percentage of the total gross value. So it works out to about 3.5–4%. So you are paying, or at least the personal representative has the option of being paid. beyond that, there's not a whole lot of other expenses other than generally the attorney's expense.
So if your personal representative gets, let's say, 10 or 20% of your will, that's a supplement to whatever the will
Well, it's not
provides.
10 to 20%. It's much
No, I'm
less than that.
saying in my case, my personal representative will be getting, I think, 20% of my estate
Okay, as a beneficiary.
as a beneficiary.
Mm-hmm.
And the part of doing the probate representative role would have a sort of an extra part.
It would be. We generally will review that with the personal representative. If they're taking a fee, it's income, so it's taxable.
Mm-hmm.
If they're a beneficiary, that's not taxable to the beneficiary.
Interesting.
And so we run the numbers, and sometimes it doesn't make sense for them to take the fee if it's going to bump them into a different tax bracket,
Mm-hmm.
or if it's just not worth it. And quite frankly, most family members don't want to take a fee. They'd rather take the inheritance.
Well, I have no children, so I've designated a good friend of mine as the representative, and then another friend as alternate representative, both in this area. And my real estate is actually, my home is going to be going to a close friend now living in Virginia, and he's in real estate, so he will take it over, and he's even agreed to pay any kind of taxes on it or whatever else
Excellent.
needs to be. He's well heeled, as they say. so that's cool and awesome. And what are some of the myths that people have about estates that we could clear up for our audience out there?
I get a lot of people who come in and say, I don't want to do a probate. I hear it's horrific and horrible, and I don't want to do it. And it's not that bad.
Mm-hmm.
Now, if I was in California or New York, I'd probably say don't do it.
Oh.
But here in Oregon, it's a pretty streamlined process, and in most cases, we're able to get to the distribution to your beneficiaries within about 4 to 6 months.
Mm-hmm.
And the truth is, if we're doing a trust administration, it's about 4 to 6 months. So there's not a huge difference in timing. It generally is more expensive to do a probate simply because we have all the added expenses of the court and the requirements. But quite frankly, it's more expensive to do a trust than it is to do a will.
Okay, I'm going to ask a curveball type question. I have a certain relative who I'm not all that close with, even though she's close in blood, but we have had our differences. I'm not putting her down publicly or privately. We've had our differences. And so in my final estate, she gets a smaller amount than she might expect. Can she challenge it and go to court, or once it's down in the official will, does it become
You know, everybody can challenge anything that they want. Whether or not they're successful is the question.
Okay.
But most wills are written so that it's very clear that your intentions are whatever's written. And so there'd be very little room to argue.
Okay. I just want to make sure that
You're
I'm-
probably good, especially
that
since I
I'm
know
not-
who did your
I
will.
don't want to come back from the grave and haunt the person and say,
No, we
Yeah.
don't want that either.
okay, I'll send emails. By the way, this is just a PS. My body is going to be cremated. Well, it's going to be donated to the research unit of
OHSU.
for research purposes. And I kiddingly say, hopefully nobody will blush. All those wonderful nurses who have never seen me in Playgirl will get their last look, if not their last licks, of what I allegedly look like.
And then I hear they'll go ahead and cremate you for free.
They do cremate me for free.
Yep.
And I want to have a donut-shaped coffin, and the epitaph will say there's no end to Lee Coin because they go round and round. I want to have a last laugh and kid around, be impish.
There you go.
Even in the afterlife or whatever.
And you can do
passes
that.
for it. I can do that. I've never seen, I don't know if there's a diversity in coffin building, but I've never seen a coffin that is anything but rectangular.
It seems like they're coming up with all kinds of interesting things now. Just the other day, I saw where your ashes can be the pod of a tree when they plant your ashes and your tree together for someone to go visit.
Okay. By the way, if you read Wednesday's Statesman Journal, that would be, I think that's May 11th. I have a guest opinion about the whole subject of death and coping with grieving. So,
I'll have to go read that.
So any of you guys out there want to do that while you're still alive, now's the time to do it.
Excellent.
No, it's really, it has to do with celebrating the birthday of the loved one, cooking a meal, playing their music, sharing a photo album, and most important of all, choosing a trait that you admire in their life and replicating it maybe once a week in your life and keep
So really celebrating the
living
individual.
flame. Yeah,
That's great.
and that's from my days as a gerontological guy.
There you go.
You have any questions for me as a as a consumer of wills?
You know, I don't know. It's not scary to me because I do it every day. So I try to, at least in our practice, we try to be aware of that for our clients. But I guess that would be the biggest question: is what can we do to serve you better?
I can't think of anything right now. I'm working with a real, well, she has her own lawyer who came to see her. I'm not involved in that. But if a will is written and then the couple gets separated and divorced, it changes the terms of the will.
It does. If you're married and you do a will, then your divorce pretty much invalidates your will. And so it's seen as if you didn't have a will. So you have to redo your will after you get divorced in order to make sure that whatever your wishes are.
But if
are
the will
followed.
has more than one beneficiary, the one the ex-spouse gets deleted, and the other person gets, or the other person or persons become the total beneficiaries. Then.
That can be one of the outcomes, yes.
Yeah. So it isn't necessary that you redo the will. It's only if you have nobody in waiting in the second or third place.
Right.
Okay, that's important to know there. Any other final comments about things that people should know? You want to mention where to contact you in your firm, not as a business thing, but if they have any questions, they could come in. You have a phone number or email?
I do. If you have questions, it's 503-364-7000. We try to make ourselves available to answer questions as much as possible.
The Garfield Building?
On
On
We're on the
Cottage
second
Street.
floor. Cottage in Marion, yeah.
Okay, so that's a place to go. You could always look at the yellow pages under elder law. You have your choice.
We're
You're
there.
a free agent.
So, parting words, I often hear from people that they didn't do their estate plan because they're immortal and they don't need it yet.
Superman!
So, unfortunately, the truth is that we never know when something's going to happen, whether it's aging or an accident. And so I always caution people, if you don't have it in place, then we have to go to court. And court is not pleasant in that it's expensive, it's time-consuming, meaning that if you need assistance, you probably need it now, and we have to wait till we get to the court. And it's intrusive at a time when families are dealing with emergencies and strife. Having to go to court is an insult to injury, but it's a necessary evil. If you've got your estate plan in place, then your agents can act almost immediately for you without having to manage the additional stress of the court.
Okay. So now you've gotten your thing down. I hope you've taken lots of notes on your legal yellow pads per the protocol. Monica and others will be glad to serve you. But don't hibernate. Don't wait until you have an imminent injury or death pending in your family.
Or a decline.
Or a decline. Do it when you're still here. I would have people do it at the age of 40 or 50, really.
I tell people to do it when they're 18.
Okay. So as
You know,
soon
once
as you're
you're an
legal,
adult, there's
do it.
nobody to make
Thanks.
decisions.
Bye now. Take care.